Good evening and welcome to our discussion this evening of the right of privacy and Montana's Constitution. We're very happy and privileged to have with us tonight former Justices James Nelson and Patricia Cotter. And I say former justices, even though they're still alive, and that's institution for judges. And unlike the federal constitution, if I were saying former justice, they would not be here with us. In addition, we have Rafe Graybill, who is very busy litigating the reach of the provisions of some of Montana's constitutional provisions in our district courts and ultimately in our Supreme Court. And I'd also like to say about Rafe, he's the grandson of Leo Graybill, the wonderful president of the Montana Constitutional Convention, without whom most of us think we would not have been able to finish our work on time. Well, I want to start this discussion of the right of privacy under the Montana Constitution with a little bit of conversation about state constitutions and why we have them. There are really two reasons. The first is rather perfunctory, and that is a territory couldn't be admitted to the United States without a constitution. And so our 1889 Constitution was really nothing more than an objective for statehood, and it did not really make any attempt whatsoever to be a good governing document or set up a viable form of government. In fact, the mining interest and the timber interest who control the writing of that Constitution really didn't want government to function at all, because they didn't want government interfering with their private business decisions. The second reason for a state constitution, the one that's more relevant tonight and is more ongoing, is that our federal constitution in Article 10 says that rights not granted specifically to the United States by this Constitution are reserved to the states. Consequently, many rights and responsibilities are accorded to our states. Anthony Johnstone at our law school has estimated that about 95% of the laws that we live under are based on state and local government ordinances and laws, and a state constitution lays out the parameters for the exercise of those powers, and through the Declaration of Rights limits the power of the state government. Now, I think almost everybody knows by now that neither the 1889 Constitution nor the US Constitution has an explicit Bill of Rights contained therein. Some people think that perhaps the delegates to the 1972 Constitution were really prescient in declaring in Section 10 of Article 2, the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. Actually, this provision of our Declaration of Rights was perhaps one of the least debated. And I think that's because both the Montana Supreme Court by then, as well as the United States Supreme Court by then, had found individual rights of privacy in both or under both the state and the federal constitution. Interestingly enough, as early as 1890, 1 year after our statehood, the Harvard Law Review published an article entitled The Right of Privacy, and it was written by soon to be a Supreme Court Justice, Louis Brandeis, in which he and Samuel Warren advocated for the development of what they were concerned about was the wide circulation of newspapers and photographs at the turn of the century that were infringing on people's right of privacy. In the article, Justice Brandeis talks about the newspapers being nothing more than gossip columns and infringing on information that people really did not want the public to know. And so in advocating for this right of privacy, he concluded that the available remedies like slander and libel, those things did not protect the right of privacy. Subsequent to that, that article, by the way, has been characterized as probably the most important and the first article ever written that really argued for a right of privacy, or as Justice Brandeis put it, a right to be left alone. Given the interest right now in the right of privacy, I think it is interesting that it was the right of privacy section of our Constitution was not more contested. But when you look at what was before us at that point, we had the first amendments to the US Constitution. It held that there's a right of privacy in the freedom of speech. There's a right of privacy in what your thoughts are. There's a right of privacy in the provision against search and seizure. There's a right of privacy in the right to not incriminate yourself. So those explicit provisions of the Constitution had given the courts grounds to find rights of privacy. And there were two really important additional provisions of the Constitution that provided room for the US Supreme Court to hold more affirmatively that there was a right of privacy. One of them was the Ninth Amendment, which is called the penumbra, or referred to as the penumbra of our Constitution. And it basically says, just because we've listed all of these rights in the Bill of Rights doesn't mean there aren't more, or there can't be more held within that are not mentioned in these previous 8 rights. So that has provided, that penumbra has provided a basis for the Supreme Court to extend the right of privacy. The other right that's very important, and it really comes into play in our federal system, as I mentioned earlier, the amendment to the Constitution, the 10th Amendment, gives all of these powers to state governments. But the 14th Amendment to the Constitution says no state shall make any law or enforce any law that abridges the privileges and immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, or property without the due process of law, or deny to any person within its jurisdiction the equal protection of the law. And the right of privacy, particularly as it has extended to freedom to choose on the federal level, has most generally been found within this 14th Amendment. Now, just to set the stage for where we were in 1972. Roe versus Wade had not been decided. It wasn't decided till January of 1973. But we had the Griswold versus Connecticut case that basically ruled that all of these Bill of Rights that I've talked about, plus the 9th and the 10th, created, or the 9th and the 14th, created this zone of privacy, that upheld that marital privacy was tantamount to the right of the state of Connecticut to proscribe the use of contraceptives. So that case, by creating the zone of privacy, then went on to establish the base or lay a base under stare decisis for the Roe versus Wade case, which I am not going to get into because that's going to be covered by other panelists. I think what is interesting, given where we are at this time in Montana, we are seeing institution as the US Supreme Court is declining to use the 9th Amendment and the 14th Amendment as a way to extend rights and to prohibit states from enacting laws that infringe on the right of citizens. I mean, good examples I think we'll talk about in voting. Clearly, voting is an issue that's reserved to the states, the right to vote. But the question is, how far can they go? Fortunately, we do not have to in Montana now. A lot of the 14th Amendment. You'll also recall under the 14th Amendment, even though marriage and the right to get married and the rules for getting married were left to the states, the US Supreme Court used the 14th Amendment and these other amendments to say, yes, but you cannot prohibit the marriage between an interracial couple. I think my point here, and I think it will be carried out through the rest of the evening, is how lucky we are in Montana to have as strong a Declaration of Rights as we do, particularly the right of privacy, and how difficult, and the fact, because of that, we are not at the mercy, or our citizens are not at the mercy of the ever-changing US Supreme Court, who seemingly has abolished the notion of stare decisis. So with that, I'm going to ask Justice Cotter to step in here and talk a little bit about, or a lot, about the right of privacy with respect to medical records, healthcare, and so on. So Pat, thank you.
Thank you, Mayman, and thanks to so many people for participating this evening. It heartens me, and I'm sure all of the rest of us, to see so many people interested in what we have to say tonight and in the right of privacy. Now, the right of privacy in the Montana Constitution is considered a fundamental constitutional right, and that makes it different from other rights that we have under the law. For example, we all have the right under the law to do such things as apply for a driver's license, or apply for a business license, or ask for permission from our county to add a room onto our house. And these are considered pretty routine rights that we have. But in the case of these rights, the state can place limits or rational restrictions on those rights, such as the state saying, yes, you can get a driver's license, but you have to be of a certain age. Or yes, you can add a room to your house, but you have to comply with zoning regulations. These are rational restrictions that, like it or not, we have to follow. But by contrast, a state cannot place merely rational restrictions on your privacy right, because privacy is a fundamental as opposed to a routine right. It enjoys a higher level of protection than the routine rights that I just discussed. Any law that infringes this fundamental right must be justified by a compelling state interest, not merely a rational interest, but a compelling interest. And the restriction must be narrowly tailored. Again, Article 2, Section 10 said that the right of privacy shall not be infringed without the showing of a compelling state interest. Now, all Montana judges take an oath to uphold the Montana Constitution. The Constitution is the very highest law in the land, so any law that is passed by the legislature must abide by the Montana Constitution and cannot violate it. If it does, the courts will strike down the law as being unconstitutional. So when a law passed by the legislature infringes on our right to privacy, people who are adversely affected or could be adversely affected by that law have the right to challenge the law in the courts on constitutional grounds. And this is what has happened repeatedly here in the last year since the last legislative session. And Mr. Graybill will address some of these cases in his portion of the presentation. Now, when a privacy right is asserted in a court, there is a litmus test that courts apply pretty routinely throughout the country and here in Montana as well. Generally speaking, if persons have a reasonable expectation that their conduct or decisions are private, and if society finds that expectation to be reasonable, then the right of privacy will protect that conduct or decision from state intrusion. For example, you would expect that your telephone conversations are not being surreptitiously recorded by the government, and you would assume that your medical decisions and your medical choices are yours to make, and that they are private unless you yourself decide to share that information with other people. So what does your right of privacy encompass, and what are the limits on that right? And is the right absolute? Here are some of the things that you should know about your privacy right. First, privacy is purely an individual right. Again, Article 2, Section 10 refers to a right of individual privacy. Interestingly enough, a previous iteration of the Montana Supreme Court declared that even partnerships and corporations had privacy interests, but we took care of that at a later time, and the court confirmed that the right of privacy belongs only to individuals. An individual is defined in Montana law as a human being, and in turn, a human being is defined, quote, a person who has been born and is alive, close quote. So relative to the reproductive issues, which will be discussed later this evening, a fetus or an unborn child does not at this point under Montana law have a privacy right as it now stands. Second, your Montana constitutional right of privacy is intended to protect you from an overbearing or intrusive government. It does not protect you from a nosy neighbor next door. The right of privacy applies to situations where the state is trying to intrude on your privacy rights. So the right protects you from police actions or state laws that might unduly intrude on your privacy. Your right of privacy extends to many facets of your life, including your right to control the circulation of your personal information, the right to control your medical records and prevent them from being disseminated, and your right to make your own medical judgments. It also refers to your right to keep private your personal conversations and discussions, in this digital age. And again, the litmus test is whether your claim of privacy is one that society would find to be reasonable under the circumstances. But the right of privacy is not absolute. The state of Montana has recognized what we call a police power, by which the state can issue regulations that are essential for the health and safety of its people. If the state can clearly demonstrate that it has a legitimate and compelling interest or reason for infringing on your privacy rights, such as for the protection and safety of other persons, then the state can impose limits on your privacy rights. Again, Article 2, Section 10 permits that if the interest is compelling. Now, a classic example of what might be a compelling interest sufficient to infringe privacy is a plague, such as which happened in the early 20th century, and of course, more recently with COVID. When there is danger to the people of the state, then state or local health boards have the authority to impose emergency powers. And as we have seen, when these emergency powers are exercised, some people resist those emergency powers, asserting their right of privacy, asserting that they have a right to be let alone by the state. So, when the state has a compelling interest for intruding on a privacy right, and that interest collides with the right of the people to be left alone, it's going to be up to the courts to apply a balancing test to determine whether the state's interest is legitimate enough and whether it is narrowly tailored to address that interest. If the intrusion is deemed acceptable because of hazards or dangers to the health and safety of the people, and as long as that intrusion is narrowly tailored, it will be upheld by the courts, generally speaking. So you see that there are all manners of persons who assert privacy interests. It could be people wanting to have their medical decisions protected from interference, or people who want to have their right to be left alone protected from what they see as an overbearing government. Finally, the right of privacy can be waived. A person may voluntarily waive his or her personal privacy rights by either agreeing to answer questions about their private information or by publicizing what might otherwise be considered deeply private information. A classic example of that is posting on public social media information that most of us would consider private. Once you do that, you have waived your right of privacy, and anyone in that public sphere, including the government, can learn and understand what should be your own private information. So now I want to turn my focus quickly to the dissemination of your medical information. So let's talk about the privacy of your medical records. In 2014, the Montana Supreme Court unanimously held that your medical records deserve, quote, the utmost constitutional protection. The case involved a woman who was injured on the job at work, and she filed for workers' compensation benefits. The insurer for her employer, under a state law then in effect, talked to her medical care providers, called her doctors and medical care providers, and spoke with them about her medical condition without alerting her that they were doing so and without allowing her to participate in that discussion. So the woman challenged the law, concerned obviously that the insurance company might undercut the confidence that her doctor had in her truthfulness. So she challenged the law and claimed that the law violated her constitutional right to control her medical information. The court found that the law allowing these chats with her doctor outside of her presence to be an unconstitutional violation of her privacy rights in her medical record. The court said her privacy rights encompassed a fundamental right to control the circulation of personal information, and said that she must be given notice of when an insurance representative wanted to talk with her doctors, and she also had the right to be present during those discussions. That right remains in effect to this day. Now, what would happen if this constitutional right of privacy was gone? Without the barrier of a privacy right, the state could pass a law allowing it to subpoena your medical records in order to determine whether you are abiding by or violating a law passed by the legislature that would restrict your reproductive rights. And you would have no way to stop it because your right of privacy would be gone. Or the state could compel doctors to disclose the identity of those who have sought advice or treatment for reproductive or medical transition issues, and you would have no privacy interest to assert in opposition. In short, your constitutional right of privacy is the barrier standing between you and the legislature. Thank you. I now yield to Justice Nelson.
Thank you, Justice Cotter. I'm going to talk a little bit about Armstrong versus State. The Armstrong case is a 1999 Montana Supreme Court decision that is Montana's version of Roe versus Wade. The plaintiffs were physician assistant certified healthcare providers who performed abortion services and were also organizations who provided counseling and referrals related to such services. Plaintiffs were prevented from providing these services to women by restrictive laws passed by the legislature, ostensibly to protect women's health, but in truth and in fact, based on religious and partisan ideologies. District Judge Jeffrey Sherlock ruled that the laws at issue adversely affected a woman's constitutional right to obtain a first trimester abortion, and that the state had failed to demonstrate any compelling reason justifying prohibiting abortions, and the healthcare providers had safely done for 20 years. In 1999, Roe versus Wade guaranteed the right of women to a first trimester abortion based upon the federal Constitution. It is a basic principle of constitutional law that while a state cannot provide less protection of a constitutional right protected by the federal Constitution, a state can provide greater protection of that right based upon its own Constitution. With that in mind, and on appeal of Judge Sherlock's decision, the Montana Supreme Court held that the core constitutional right infringed by the legislation at issue is the fundamental right of individual privacy, guaranteed to every person under Article 2, Section 10 of Montana's Constitution. The court held that the personal autonomy component of the right of individual privacy broadly guarantees to each individual the right to make medical judgments affecting her or his bodily integrity and health in partnership with the chosen healthcare provider, free from the interference of the government, except in very limited circumstances. The court ruled that Article 2, Section 10 protects a woman's right of procreative autonomy, that is, the right to seek and obtain a specific lawful medical procedure, a pre-viability abortion, from a healthcare provider of her choice, and that the government failed to demonstrate in that case a compelling state interest for infringing upon these rights of privacy, and that therefore the laws at issue were unconstitutional under Article 2, Section 10 of Montana's Constitution. Importantly, the court's decision was based solely upon Montana's Constitution, independently of, but granting greater protections than the federal Constitution. Thus, the court's decision being decided on independent state grounds, Montana's Constitution continues to protect women's right of reproductive autonomy, despite Roe versus Wade being overruled by the United States Supreme Court. So going forward, what is the legislature's role, if any, in controlling women's right of reproductive autonomy? In my view, the legislature must acknowledge and honor women's right to control their own reproductive functions and their decisions regarding those made with their chosen healthcare providers as guaranteed as a fundamental right under Article 2, Section 10 of Montana's Constitution. That is the Constitution that each and every legislator, governor, and attorney general takes an oath to support, protect, and defend, incidentally. Religious and partisan ideologies have no part in these medical decisions. The legislature, governor, and attorney general must give up their obsession to marginalize women by controlling women's bodies and chosen course of life. The legislature has no more right to control women's bodies any more than it does men's, and it is most certainly not trying to control men's bodies. That's really all I have to say on the subject, Maine Anne, so I'll yield to Mr. Ringo.
Thank you, Justice Nelson. One of the cool things about being in a seminar like this is you get articulate, intelligent, good commentary from people like Justice Cotter, Justice Nelson, and me. One of the things that they didn't necessarily tell you that I want to tell you is these folks are primary source documents. They're the authors of some of these provisions we're talking about. So I think it was mentioned at the beginning, but Maine Anne was among the delegates in the Montana Constitutional Convention. Justice Pat Cotter and Justice Nelson authored important decisions on privacy in the Supreme Court, and Justice Nelson, neutrally applying the law, was in fact the author of the Armstrong decision he just described. So you have a really stellar audience or stellar panel here, and you also got me. So I will briefly walk you guys through 3 sets of cases that I think really highlight the ways that the right to privacy is working out in contemporary cases in Montana courts. And I want to focus on 3 buckets in the ways that the right to privacy is at issue in different cases. The first set of cases I want to talk about is there's a series of challenges right now following Armstrong and that are heavily influenced by the changes in federal law that deal with the extent to which the Montana legislature can regulate access to abortion in Montana. I'll disclose at the start, I am lead counsel for Planned Parenthood in one of these cases that I'm talking about, so I won't give you inside strategic details, but I think it's important for you to know about because they are the sort of the front lines of this particular question. So in the 2021 legislative session, Montana did not have divided government for the first time in many, many, many years. The same party controlled both houses of the legislature and the governorship. And that meant a whole slew of new laws that legislators wanted to pass for a long time became law, whereas previously they would have died somewhere in the process. And as it pertains to abortion care, the legislature passed 4 laws in particular that are currently the subject of a challenge by Planned Parenthood. One law bans abortion after 20 weeks, which is universally considered to be pre-viability. Another law places severe restrictions on medication abortion. It requires all sorts of credentialing and you can't do it by mail. Another law requires providers to offer, as the word of the law, an ultrasound image to someone seeking an abortion. And there is a ban on certain kinds of insurance coverage. So based on the Armstrong decision, we went to court in Billings, where Planned Parenthood is headquartered, and challenged these laws and said, if Armstrong and the right to privacy are about anything, they're about the government can't insert its preferences into the most private medical decisions someone has to make. And using a procedural method called a preliminary injunction, basically you tell the court, we think you shouldn't allow these new laws to take effect until the court has time to really think it through and reach a decision. It's kind of an advanced procedure to get early relief. We went to the court, sought relief on those 3 laws, and the court decided, yeah, we should pause. These 3 laws shouldn't come into effect until there's a time to hear out the whole case. Now, normally that ends things in a case like that for the time being. Then you go through the normal process of developing your witnesses, figuring out who's going to testify at trial, making motions. But in this case, the state, which and the new attorney general, Austin Knudsen, decided to appeal and said, not only should these laws take effect, but Montana Supreme Court, you should in fact overrule the Armstrong case. And that's something you almost never do this early in a case. It's procedurally improper to do that because they haven't considered there's no record in the case yet. There's been no trial, no summary judgment. Now, when the case was up on appeal, the Dobbs decision came down from the US Supreme Court, overruling Roe v. Wade on a federal level. And the state chimed in again and said, please, 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 Montana Supreme Court, you really should reconsider Armstrong. And in a decision that came out August 2nd, or August 12th, about a month and a half ago, the Montana Supreme Court said the district court was right. These are really big changes. The district court was allowed to make the determination that these new laws challenge or at least infringe upon the right to privacy, and they should remain paused until there can be a full hearing at trial. And perhaps because the state asked so insistently, the court was very explicit. No, we're not going to reconsider Armstrong right now. And if the state's argument were right, that somehow Armstrong were tied to Roe v. Wade, maybe the court would have done that, but they said, we're going to leave Armstrong alone. Now is not the time. And that case is scheduled for trial about September of next year. Very briefly, a couple other, so that's sort of what's happening right now in abortion litigation. There's also a case about a parental consent law that was passed many years ago that was on pause, that's kind of come back to life. And there's another case at the Supreme Court about whether advanced practice registered nurses can perform abortion services. So those are kind of the abortion cases happening now, dealing with the right to privacy. Another interesting case came out about a month ago from the Supreme Court, where a group of parents sued the school districts in Bozeman and Missoula, saying that they did not want their kids to have to wear masks during the 2021 school year. And one of the arguments the parents made was, if the right to privacy involves the right to make medical decisions, then we should get to make the medical decision for our children not to wear masks. And the district court in both cases rejected these arguments, and it went up to the Supreme Court, and it really tested out privacy in a different way. There's been a lot of cases about the right to access abortion care, not so much on where public health intersects with private medical decisions. And the Supreme Court roundly rejected these arguments. Supreme Court, in a decision by Justice Rice, went through all the arguments and said, no, wearing a mask or being subject to a mask requirement isn't medical treatment. It's preventive, if anything. And that deals with the realm of public health and public health decisions. When you leave school, you don't have to wear the mask anymore, but in school, schools get to make public health decisions. There was actually a line in the decision I want to read you where they said, wearing a mask is no more medical treatment for a disease than a motorcycle helmet is treatment for a head injury. They're both preventive. They come before, and it does not, the court said they didn't make out a case that it violates the right to privacy by saying you got to wear masks in schools for that school year. The third tranche of cases I want to discuss deals with another hot button issue out of the 2021 legislative session, which is vaccinations and vaccination requirements. To recall, there's been quite a controversy over federal efforts to require COVID-19 vaccines. I'm the lawyer in one of these cases as well, so I'll disclose my interest and probably my bias on the issue. But the Montana legislature decided that it was going to ban vaccination requirements in the 2021 session. And they decided they weren't just going to ban vaccination requirements for COVID-19, they were going to ban all vaccination requirements. So your pediatrician can no longer require the nurses to get the Tdap vaccine, even though pertussis is fatal to infants. Public health offices can't require the hepatitis B vaccine for people that handle needles. All of that is not only gone, it is illegal in the state of Montana. And this case implicates the right to privacy. So a group of doctors from the Montana Medical Association sued. I represent the Montana Nurses Association. Our clients sued. And the basic arguments were, it's very difficult to give safe patient care for the doctors and to enjoy a safe workplace as the nurses if you can't require the kinds of ordinary vaccinations that have been a bedrock principle of American healthcare for decades. Now, this is an issue, the case where the right to privacy comes up in defense. And so the state, in saying we get to make these kinds of decisions, we get to tell, partners in pediatrics and Helena that they can't require any vaccines, their interest is the right to privacy. And they, our claims are on the basis of, our clients have to follow various federal laws about workplace safety, accommodating disabilities. There's a bizarre exemption where certain facilities don't have the law and some do, and that creates problems. But this is a case yet to be resolved where the state's defense is privacy. And sort of similar to the mask case, it raises this question about what are public health decisions and what are private health decisions. It is the case in every other state in America that we allow private employers to make the choice about what vaccinations are appropriate for this line of work. In Montana, that is something that is no longer a private decision by medical professionals. It's something that the Montana legislature has decided for them. So that case is scheduled to go to trial in 3 weeks before Judge Malloy in federal court in Missoula. And there is also a similar case brought by a private non-medical business called Netzer Law Office. And that case is before the Montana Supreme Court. It's not quite as far along, but it challenges the same law and the same issues. So yet to see what courts do on that case, but it'll be an interesting one to watch to see, again, how public health and private medical decisions interact with each other. And with that, I'll hand it over to Mainan. And Mainan, you may be on mute.
I am now unmuted. Wow. What a lot of really good information in a relatively short period of time, I think. And so we've left ourselves with some really good time for some questions. And I want to invite all of the panelists to feel free to ask a question of each other. I want to ask a question immediately following on to Ray. What was with respect to the vaccination regulation in federal court as opposed to state court?
And you broke up for a second. Is the question, why is it in federal court, not state court?
Yes.
So the medium answer, there's three basic problems with the law as it was written in Montana. One of the problems is if you're a doctor's office or a hospital, federal law requires that you accommodate people with disabilities. And that can include having an immune condition, for example, that makes you vulnerable to vaccine preventable disease. But if the state comes in and says, you can't require any vaccinations and you can't even treat people differently based on their vaccination status, that makes it really hard for healthcare settings to accommodate people. So someone might come in and say, I'm going to make this up because I'm not a doctor. If I get measles, I will die. I have a really bad condition. Well, normally in any other state in the country or in Montana before a year ago, the hospital could say, okay, we're going to check our vaccination records and we're going to make sure that your treating physicians and nurses are all immunized against measles. And maybe someone isn't, maybe for an ideological reason, but maybe because, they can't get that vaccine for a medical reason. That's fine. That caregiver wouldn't give you care because it could get you sick. That series of events I just described is unlawful in Montana right now. One of the things we discovered in that case was, and this is all in the public record, there was a cancer survivor conference in Montana for cancer survivors. And this conference said, we want you to be immunized for COVID-19 to come. If you're not, that's fine. We have a Zoom option like all of us are doing right now. And the state of Montana found that practice, saying there's a Zoom track for non-immunized people, was illegal and fine. I don't know what they did, if they fined them or not, but they found against them in a judicial proceeding based on that. So to your question, why is it in federal court? That requirement to accommodate people with disabilities, a similar requirement to have a safe workplace, those come from federal laws. So you go to federal court, state laws, you go to state court typically.
And but you said one case, the Netzer case, it's in state court.
Yep.
And does that case deal with the ability of an employer to make requirements? I mean, this other case, you're coming at from doctors not being able to do certain things, but the Netzer case, that's where, like a business, if they make a determination that they think each of their employees should have a vaccine, they cannot do that under this Montana law, right?
Yep. So the federal case is unique to healthcare settings.
Got
And
it.
the
Okay.
doctors come at it from, how do we give the best care? The nurses come at it from, we work here, we want to be safe as we work here. And the Netzer case is sort of all businesses generally. And that one got a little bit hung up in the early stages, and they're on an appeal right now.
Okay. Justice Cotter, I'm wondering, kind of in light of what you've talked about, what Justice Nelson has talked about, and what Rafe has talked about, kind of what do you see what are some of your biggest concerns right now about what's going on in Montana?
Well, I guess my concerns would be twofold. I'm concerned on the one hand with what appears to me to be an attempt to politicize our court system, to politicize the Montana Supreme Court. There has been bills introduced or initiatives introduced to try to control, to compel one justice to be from one different district from around the state, which would give the people in that district the right to vote for one justice, but not the right to vote for every person who's running for the court. And the attempt there seems to be to make the court regional, so that make the justice from a particular region pay attention to the regional desires in politics, essentially. I don't like the idea of politicizing the court or trying to control how people are elected to the court. I'm also troubled by there was something else I wanted to say about that. I can't come up with it at the moment, but I guess my other biggest concern is that it seems to me that right now the legislature, for either political or religious reasons, seems intent upon appropriating our privacy interests, taking away our privacy rights, and having control over our personal medical decisions, whether it's out of fear of or disgust over any gender, sexual, or reproductive decisions that the state finds offensive. The state seems to me to be intent to tell us what we can and cannot lawfully do with our body and who we can lawfully love. I fear that if things go in this direction, and if some of the rights that have been understood to be intact and to be supportive of people with different ideas and ideologies, if some of those rights are assumed by the government, we're going to go back to the good old days of repression and persecution of persons that seem to be outside of what the state considers to be the mainstream. And I don't want to see us go back to that time. So it's the politicization of the courts. The other thing I was going to say about that, if I can add one more thing, is that historically, people who are running for the Supreme Court do not run as Republicans or Democrats. They run as independents, and they do not accept endorsements from political parties. In fact, our Code of Judicial Ethics precludes judges or judicial candidates from doing that. But in the latest race, the Republican Party is up front in terms of endorsing a particular candidate for the court, and that candidate has accepted those endorsements. And so, again, it's another example of politicalization that is uncomfortable.
You know, it seems to me that the big issue right now is, or it stems from the legislature or the majority of the majority party And I emphasize that the majority of the majority
Right.
party seems to want no limitations on what they can do. I think there's a basic unwillingness to accept the Constitution as something that controls the legislature's ability to act. I've heard that legislators will be told that certain bills that they seek to have introduced are unconstitutional, and they introduce them anyway. So I think they don't like the notion that the Constitution limits them, and they don't like the courts interpreting the Constitution, which is what the court's job is. I feel like there's such an aggrandizement of legislative power and not a willingness to recognize the power of, or the authority of, the Supreme Court in our system of checks and balances and separation of power. And I find that alarming, because I think for so long, we have generally accepted the notion of these three separate branches of government, and each one of them, for the most part, trying to stay in their sphere. I mean, there are times when I guess someone really doesn't know what the Constitution says or what a certain provision means, so they can go forward. But it seems like there's just a two-pronged challenge. And I want to ask Justice Nelson to talk a little bit about the threats that he is seeing, how these threats will come about, or the potential for changes in our Constitution can come about in the near term, other than the change in the makeup of the court.
Well, Maynard, one of the biggest threats to the integrity of our Constitution, I think, will come if the legislature obtains a supermajority, and that's defined as 2/3 of each house of the legislature. If the legislature obtains a supermajority as a result of the November elections, and I think there's a reasonable chance that that may happen. If the legislature obtains a supermajority under Article 14 of the Constitution, the legislature can call for an unlimited constitutional convention and place that on the ballot for people to vote on and in the next general election. And the legislature can also place on the ballot a referendum to amend or change or rewrite certain provisions of the Constitution. Now, if the supermajority of the legislature calls for an unlimited constitutional convention, know this: every legislator has a bone to pick with some provision or protection guaranteed in Montana's Constitution. So every one of those provisions and protections will be on the chopping block and up for grabs in an unlimited constitutional convention. For those of you that have seen Shark Week, think Feeding Frenzy. Here's a summary of what we, the people, have to lose. And some of these rights have been mentioned already. And I mention these because they are not only important rights, which could suffer a greater deprivation than they already have, but in most cases, the legislature has already tried to limit these rights. So let's talk about what have we got to lose. The right to seek safety, health, and happiness in all lawful ways. The right to a clean and healthful environment. The inviolable right of human dignity. Freedom from imposed religious ideology. freedom of assembly and the right to petition the government with our grievances, freedom of speech and expression, the right to participate in government, the right to know, the right of individual privacy, and the right to reproductive autonomy, the right to vote and of suffrage, rights of persons not adults, the rights of persons accused of crimes, giving the legislature more power over the courts and elections, giving it the ability to gerrymander, and essentially making the legislature the most powerful branch of government, thus destroying the separation of powers and checks and balances, weakening the courts as a branch of government, and ensuring that judges are appointed and elected based on political and religious ideologies, weakening or obviating the legislature's duty to maintain and improve the environment, weakening or obviating the legislature's duties to guarantee a free, quality public education and to recognize the unique cultural heritage of Native Americans, weakening local government powers and giving those powers to the legislature, dumping the Consumer Council, making it impossible for we the people to legislate through citizens' initiatives and referenda. Believe me, the legislature has done a good job of that in passing House Bill 651 in the last session. I would say this to you: democracy is not a spectator sport. Every one of us must form our own vision of our Constitution, what our Constitution can do for us, our families, and our fellow Montanans in our daily lives. Every one of us must do our part. We've got to vote. We've got to support candidates that support our vision of the Constitution. We need to go to candidate forums and cross-examine candidates as to what they see in the Constitution. Will they uphold it? Will they abide by their law to support, protect, and defend the Constitution? We need to give money to candidates that support our views. And we need to speak out constantly about legislative attempts to control the courts. Every one of us, every single one of us must stand up and speak out against legislative efforts to weaken or destroy our Montana Constitution and its 50 successful years of being the fundamental organic law of our state. If we don't fight to preserve the Constitution and our rights, then we'll lose them. And it's just as simple as that.
Justice Nelson, thank you. I'm just wondering if our Constitution, which was written for this and future generations, and I really think of Rafe on this panel as being the future generation, wondering how optimistic or pessimistic are you at this point in our constitutional history and in your work?
Well, let me say one thing. Rafe kind of praised up the judges on this panel and you, Maine-Ann, and I would have to say that were it not for good, ethical, zealous trial lawyers like Rafe and other lawyers in the profession, there wouldn't be any cases for us judges to judge. So he kind of sells himself short, I think.
I totally agree.
I'm sorry. I guess I'm always kind of a sort of a glass half full sort of guy. I have faith in the majority of Montanans to make the right choices in picking candidates and in voting on calls for a constitutional convention. What I fear most of all is the majority parties, the Republican parties, often successful attempts to misstate facts, to lie, frankly, outright. Joe Biden didn't actually win the 2020 election. to mislead people and to provide misinformation. And people believe that, especially if it appears on the internet. My God, it's on the internet, it must be true. I don't know why we don't think, my God, it's on the internet, it probably isn't true. But those are the things that concern me. I think that there's a very real possibility that despite the goodwill and the good intentions of most Montanans, many people are going to be led astray and buy into some of the misinformation and outright lies that we've been provided with in the last legislative session and what you're going to hear in the next legislative session, to be sure. So I guess I'm both optimistic and at the same time pessimistic. Again, that's why I think it is so absolutely so important that every one of us, every Montanan that values our Constitution and values the rights that we have enjoyed for 50 years under the best Constitution in the country, every one of us has to stand up and speak out for our Constitution and its rights.
Rafe, would you like to add anything?
As the young one, no, I agree with Justice Nelson. I mean, I am not a believer in fate. I'm a believer in choices and in collective choices. And I think that a lot of what we do in the next 50 days in this election and the next few years about how we think about courts and our Constitution is really going to matter. I think it's really important to have forums like this where people can learn about what's going on in the legislature and what's at stake in our Constitution. The thing I worry the most about, but I think we have something we can do about it, is what Justice Cotter and Justice Nelson both mentioned, which is this politicization of courts. I have been lucky to have some success in enjoining some laws recently, and every time it happens, the other side releases a press statement that says, oh, these Democrats in black robes, it's just a Democrat conspiracy against the legislature. And, that's not how the rule of law works. And I really worry about, forget the political cases. Say you get hit by a bus. You don't want to have a Democrat judge or a Republican judge on that case. You want a fair judge, a neutral judge. And if we don't have that, if everything is through this lens of politics, it's hard to have the rule of law. And as a young lawyer, you think, what's the point if you're just everything's going to be partisan politics? But I really think that people fundamentally in this state don't want their courts to be political. They want their courts to be independent and apply the law neutrally. And here's the last thing I'll leave you with. There's this discussion right now, including in this forum, about all this constitutional litigation going on. Is the legislature pushing the boundaries? Is that activism? Is it not? And I want to challenge everyone out there to think of our courts as fundamentally conservative institutions, not activist institutions. When you see the Judge Moses on last Friday say that these 3 new laws that hurt the right to vote are unconstitutional, what he's doing is something very conservative. He's saying this higher law, the Constitution that binds us across different elections and legislative sessions, that's gonna be what the law is, not what 150 people who got together 1 year, one time thought we should do. And whenever you see a court strike something down as unconstitutional, think, is this a conservative move? Is this keeping things the same, preserving the values we've all committed to in our Constitution? That's how I think about it, and that gives me a lot of optimism.
Well said. Thank you. Pat, we have just a few, 2 or 3 more minutes. Would you like to offer anything as final comment?
I would. After listening to Rafe and Justice Nelson and to you, Maynan, I think we have to go back to the proposition that this state is comprised of fine people, fine Republicans and fine Democrats. There are people who are bent on pushing the law, pushing the limits of the law. But I don't think we can say it's only the Republicans doing that. It's only the Democrats doing that. Let's focus on the center core of all the people across the state, the people who want our institutions to be protected, who want their rights to be protected, and ask that they look not to divisiveness, but rather to inclusiveness, and to look to ways in which we can preserve the rights that we have in our Constitution. And I think that that message must go to all of us across the state, whatever party we're in, that it is vitally important that we save our democracy and that we save the rights and the fundamental rights that were given to us 50 years ago in our Montana Constitution, and that we uphold that Constitution.
Well, I would like to close on that by simply reiterating that this Constitution is totally built on we the people. Throughout this Constitution, there is the inviolability of the right to vote, the sanctity of the right to vote, the ability of the citizens to amend their Constitution, to enact laws, to repeal laws that the legislature has enacted. The core belief in this Constitution is this Montana to govern themselves. And I do believe that they will do the right thing. I do believe that they value this Constitution and will vote to uphold it. So I want to thank all of you panelists. I want to thank Mary and the League of Women Voters, Suzanne at the library, and all of the viewers who have listened in, and just hope that you take away something that's valuable to you from this little over an hour that we've spent together. So thank you all and good night.